Hi, I'm Larry Marshall from Larry Marshall Law Firm. For international real estate investors, we always recommend to get in touch as early as possible in the process due to the extra work required. Normally, a lawyer won't begin work until the agreement of purchase and sale is final. However, if the time frame is short, it may be necessary to get started right away. A lawyer's role involves the title and non-title searches in the case of single-family residential being more basic. More is required if it's commercial, industrial, multi-unit residential. If it's an investment property to be rented, there are other considerations which may mean other searches as well, review of tenancy agreements, etc. If the purchase is a condominium unit, a review of status certificate for arrears, special assessments, legal actions, etc. There are also documents to be prepared, some based upon mortgage instructions. As the lawyer, I am not in control of the timeline for mortgage instructions. It is very important to get those going early and to impress upon the lender the need to get them out quickly, especially if you are an international real estate investor. It will be necessary to make arrangements to send documents overseas. Before closing, usually a few days, I'd need to receive the hard copies since some lenders require that. The buyer, being a real estate international investor residing outside Canada, does not have to be present in the country for closing. However, it will be necessary to locate an overseas solicitor, email the documents to her/him with a review and explanation on how to sign. I'll have to take steps to try to verify that solicitor, have the buyer attend to sign, get PDFs and hard copy back, and to have that lawyer see, verify, and make certified copies of ID. Having said this, some financial institutions to secure a mortgage for a non-resident international investor will not accept signature by power of attorney, or if it's signed out of the jurisdiction. That discussion with proposed lenders is important. Strongly recommend pre-approval, particularly to have those issues discussed with your lender. Title insurance in theory is not mandatory, but in practice most lawyers highly recommend it these days to protect against mortgage fraud, identity theft, and forgery. This is a growing crime, particularly in large urban areas. Some financial institutions are demanding it as well to secure a mortgage, so practically it's necessary to obtain it on practically every file. The cost on a $500,000 home is a few $100s. In terms of costs, the biggest cost is the land transfer taxes, one charged by the province of Ontario, the other by the City of Toronto, assuming the property being purchased is in the City of Toronto. The tax rate increases at several levels based upon the purchase price. For the Ontario tax, it is 0.5% of the first $55,000, 1% of the next $195,000, 1.5% of the amount above $250,000 up to $400,000, and 2% of the amount above $400,000. The Toronto tax is almost the same, except the rate does not increase to 1.5% on the amount from $250,000 to $400,000, so that it is slightly less than the Ontario tax. Other costs include disbursements such as search costs, registration costs, conveyancer, courier, copies, title insurance, etc. There is some variation. It depends upon the property and the purchase price, but in most cases for properties below $500,000 purchase price, the range is $700 to $800. In terms of a legal fee, there is the flat fee charged by me, the lawyer representing you, and if it is necessary to make arrangements for you to sign remotely before another solicitor in a different country, there may be other costs that I'm not able to estimate. For example, that may include a fee to the remote lawyer you may consult. Depending upon the lender, there may be some deductions from the mortgage advance, such as realty tax holdback, interest adjustment, appraisal costs, etc. It's often just a day or two before closing that I receive the statement of adjustments from the seller's lawyer. In case your bank account and fund to purchase are located overseas, an estimated cost may be necessary so that funds can be wired in advance, as this process may take a few days. That way you are ready for closing. On the day of closing, the mortgage advance is received, as well as funds from the buyer and the buyer's documents. There is an exchange of documents, keys, and funds on the day of closing, and once that is complete, keys and funds are released, and the buyer has possession. I always suggest that locks be changed after closing. After closing, I can send a copy of the registered deed and a written report is provided. If the property is an investment property, retaining receipts for all costs is important for tax purposes. It's also important to review with a non-resident buyer some of the aspects for when they become a seller, particularly the requirement of obtaining a Section 116 certificate pursuant to the Income Tax Act. That requires that 25% of the sale proceeds be retained by the seller's lawyer until that certificate is obtained. It isn't issued until the seller files their tax return for the period, and it's assessed so that it can be months before these funds are released. That, of course, can be a source of frustration, but there's no way to avoid it. If the seller is a non-resident at the time of sale, which is not the same as citizenship, it is based upon residency.